Welcome back to New Money. We're talking estate planning this evening. My guests are Harry Joffe and Gordon Stewart. Gordon, I'm coming back to you. We were talking about wills. Please carry on with what you were saying.
Yeah, so you asked how simple is it to draft, or how easy is it to draft a simple will? And what I'm going to say, Harry, is that I'd exercise, Bryan, I exercise caution when it comes to simple wills. I know you can go and buy these templates from, I think, what's it, CNA or paperbacks or whatever's still left in SA.
And now, Gordon, now ChatGPT.
Yeah,
now ChatGPT.
Oh, yeah, or chat, yeah, that too. So I think you've got to be quite careful of that, because the one thing that I must say is that the will is probably the most important document that you will ever sign, just simply because once it becomes effective, it's too late for you to go back and make any changes. So now that it's Wills Week in South Africa, I know that there's a number of legal firms and fiduciary service providers who will actually draft that will for free. So just a couple of key factors to take into consideration. First of all, obviously, who do you want to benefit? So who are the heirs to your estate going to be? Then you must also take into account your marital contract, because that'll determine the quantum of the assets that you can bequeath. I remember once having a discussion with a particularly angry client who was wanting to bequeath 100% of his estate. And I was trying to tell him, well, actually, you can only bequeath 50% because he was married in community of property. And then one of my favorites is, obviously, you need to be very, very careful when you're dealing with offshore assets, for the simple reason that a South African trust cannot directly own a foreign asset. Then don't forget about the basics. Who's the guardian of any minor children going to be? You want to ensure that collation is excluded. And then the age-old question, do I need one will or do I need multiple wills?
Okay, thank you. Harry, let's just talk about another issue. There's a big discussion relating to beneficiaries of wills, policies, retirement funds, alternative beneficiaries. Just throw some light on that.
Yeah, so let's just break it down, Bryan. So, I mean, retirement funds, of course, your beneficiary is not so important because of the Pension Funds Act, where it pays to dependents. So we'll leave that out. When it comes to a life policy or a will, carrying on with what Gordon's saying, there's never a simple will, because something we picked up at Discovery Wills and Trusts, you know, we've been in business a month now. Bryan, I thought you'd wish us congratulations. But what we picked up is this alternative beneficiary is a very important issue. So, case we had now, husband, spouse, 2 kids from his second marriage and 1 kid from his first marriage. So he leaves everything to the spouse as normal. If the spouse dies with him, he leaves it to the kids. If the spouse and the kids all die together, he leaves it to a trust. But of course, what he didn't pick up is he's got 3 kids. 2 of the kids live with him. The 3rd kid doesn't live with him. So if there's a wipeout and the family are wiped out, him, the spouse, and the 2 kids, the 3rd kid is likely not to be wiped out because he doesn't live with him. Now that alternative beneficiary clause, in other words, that family wipeout clause, which everyone has, saying if me, the spouse, and kids are all killed together, it goes to the trust, won't kick in here because the 3rd kid will still be around, if you're following me. And that would mean the 3rd kid would actually pick up the entire estate by virtue of the Interstate Succession Act for the balance of the kids, because the 3rd kid is the only family member standing, which is not what he wanted, because then invariably it goes to the ex-wife.
Harry, it even goes further. Husband got 2 children by the second wife, dies, leave money to the wife. The wife dies, she leaves it to her 2 children, cutting out the 3rd child.
It's the same problem. It's that railroading effect. How do you want the money to go? So we've actually created a system now at Discovery Wills and Trusts where we call it silos. So you leave assets to a beneficiary, you have a backup beneficiary for that beneficiary only. And you don't have a backup beneficiary only coming in if the whole family are wiped out. So there's a wipeout clause and there's an alternative beneficiary clause in a silo for that beneficiary. Now, very important, Bryan, on a life policy, it's the same problem. So now you make your spouse a beneficiary on your life policy, but if you are killed together with your spouse, then there's no beneficiary on the policy, and it goes into your deceased estate. And that's not what people want, because they want the policy to create liquidity and not be caught up in that estate. So some insurance companies, and we are busy in the process of doing it, allow an alternative beneficiary on a life insurance policy. So you nominate your spouse. If your spouse is killed with you or within 60 days of you, then there's a backup beneficiary on your life insurance policy. And that's such an important issue because you want that beneficiary to kick in on a simultaneous death. So not all the insurers allow it yet.
But Harry, that's not part of your will, because that's part of being a beneficiary.
Correct.
Of a life
Not part of the
policy.
will.
It wouldn't come into that department. You'd need to talk to your broker, and your financial planner,
Yes,
or your agent, and say, let's just have a look and relook. And that's another thing. People don't relook at their beneficiaries very regularly.
No.
They may even draft a relook at their will more often than they look at their beneficiary nominations.
I mean, Bryan, and I've got to put this out there. We had such a lovely case where I just laughed, but it's not funny. We had spouses that are divorced. Now, the husband is now the owner of the policy. The wife didn't, in the divorce agreement, think about the policy. So now it's a joint policy. Husband and wife are both on this policy, even though she's now an ex-spouse. She's now had a disability claim. And we are paying the husband as the owner of the policy, the ex-husband. And now she's furious, of course, but it's her own fault. She should have sorted it out in the divorce agreement. She should have changed the ownership. And that's such an important issue. Who are the beneficiaries? We have so many cases where ex-spouses are still beneficiaries on policies. And Gordon would know in the Wills Act, if you die within 3 months of a divorce, you can't inherit in terms of the will. That doesn't cover the policy. The policy, if you die, there's no protection in the Wills Act, because as you said, it's not part of the estate or part of the will. So these are very important issues to consider.
Gordon, anything you'd like to comment on?
No, I just think it's actually quite a clever thing that Harry's come up with, because in the olden days, the only way to really deal with that was to make the estate the beneficiary of the life policy, and then try and regulate it through the will itself. But it's, Harry's kind of this, they've cut out the need for it to go to the executor, who would no doubt take fees on it.
Yep.
And you can now do it through the policy itself. I think it's quite clever.
Yeah. Gordon, let me talk to you about, because people don't tend to get married like in my day. Everyone seemed to get married. Today, people are living together. What do people cohabiting together need to do in terms of both, in terms of what they can ultimately inherit or have to continue paying if something happens to their marriage or their relationship? And secondly, what are the tax consequences?
Okay, so you're right when you say that there's a lot of unmarried couples living. And before the show, I did a quick analysis, and it looks like there's around about 3 million South Africans that are living in so-called life partnerships. I don't know how accurate that is, but that's the figure that came out. So what was interesting is that in 2021, the Constitutional Court held that Section 1 of the Interstate Succession Act is actually unconstitutional insofar that it excludes life partners in a relationship intended to be permanent from the definition of a spouse. The court also held that Section 2 of the Maintenance of the Surviving Spouses Act was also unconstitutional, and that it should include a partner complying with the test of reciprocal care, maintenance, and support. That's the crucial thing here, Bryan, is that this is not applicable to someone who's just started living with their casual girlfriend. It's meant to be applicable to those who are living in a serious relationship, where each one of them takes care of the other with regards to that maintenance and support. So,
Sorry, Gordon, I just want to jump in. And Gordon's 100% correct, but of course the point is the executor will always reject this claim by the casual spouse, let's call it. And you're always going to have to go to court. I mean, the court will uphold it eventually, but you have to go to court and you have to fight it out in court, because the executor and the master won't allow these claims.
Yeah, because you've got burden of proof. Exactly. So, I mean, just a couple of practical steps that I was thinking of that people can follow is draft a cohabitation agreement, just outlining things like property ownership, financial contributions, and terms for separation. Any joint property that you've acquired together should be documented. Draw up a proper will, and then also just proper financial planning. So just ensure that your insurance, your pensions, bank accounts reflect the couple's intention. What I'm not sure of, Harry, and I'm going to pass this one back to you, is I know the Constitutional Court held that they were unconstitutional, but have any legislative changes been made to change those two sections?
So interesting, Gordon. So I'll come back to it now, but Bryan, on the tax side, which you raised as well, in the Income Tax Act, a common law spouse is recognised, because the State Duty Act and the Income Tax Act say any permanent relationship qualifies as a spouse in terms of the definition of spouse. Of course, as Gordon said, you've got the burden of proof to show SARS this is a permanent relationship. But SARS have actually got a list which they've put out what you need to show them that it's a permanent relationship. You know, shared accounts, shared expensive, accounts going to a shared address, all those kind of things.
Beneficiaries of medical aid.
Yeah, exactly. You've got to show, and of
wills.
course, socially, you would have to provide some kind of proof from socially that you're seen as a couple and things like that. But again, it's not a given. You'd have to prove it to SARS to get the
Harry,
state you'd in.
Gordon, would you suggest that such a document is drawn up by an attorney?
Yes,
Oh,
I mean, a
definitely.
cohabitation agreement, definitely. The other things
Definitely.
can just be like a social agreement. You know, people say, for example, the priest at your church can say that they're a couple, things like that. But back to Gordon's question, Brian, I think we're going to run out of time. So the Constitutional Court said those laws have to change. There is a new Marriage Act being drafted now, which will change definition of marriages, and it will include a lot of the stuff. Whether the Maintenance Act has been changed, as far as I'm aware, it hasn't been changed yet. It's also all in the process. There's a lot of acts being drawn out. We saw a draft version of the new Marriage Act, what marriages are going to be. And if that Marriage Act changes, Gordon, that will automatically, of course, change everything else. Because if you recognize as married, then it will change all the maintenance and all those downstream laws.
Well, guys, we run out of time as usual, and I can tell you, I'm going to have a lot of very upset people who sent me emails. I will personally give you my word. I will call you this week, and I will deal with your question, and I will probably deal with it when I bring Gordon and Harry on, so they can just confirm information I've given to you. But South Africans need to recognise that for many years it was possible to circumvent certain trust requirements. However, since the grey listing, the rules and regulations have been significantly tightened. I strongly recommend that anyone with a trust review their past actions to ensure that going forward they fully comply with all trust regulations. Very important, and don't ignore that. Harry, Gordon, I'd like to thank you for joining me this evening. It's important to note that our program is to provide information and should not be construed as advice. Next week's program, we will once again be dealing with, and I just have to run through my notes quickly, apologies for that, we're dealing with investments. I look forward to that because we've had an enormously good September, and thank you for watching. Good night.